Welcome to our comprehensive video on the Employees Provident Fund and Miscellaneous Provisions Act, 1952. This video lecture will delve into the applicability of the Act, its various provisions, providing you with a thorough understanding of this crucial component of India's social security framework. Let's look at the key milestones in the history of the Employees Provident Fund Act. On 15th November 1951, the Employees Provident Fund's Ordinance was first promulgated. On 4th March 1952, it was replaced by the Employees Provident Funds Act. By 2nd September 1952, the Employees Provident Funds scheme was framed. The Act initially applied to 6 industries: cement, cigarettes, engineering products, iron and steel, paper, and textiles, starting from 1st November 1952. On 31st December 1956, it was extended to include newspaper establishments. Finally, on 31st December 1960, the coverage limit was reduced to factories and establishments employing 20 or more persons, as opposed to the previous threshold of 50 or more persons. The Employees Provident Fund Act is compulsorily applicable under 2 primary conditions. To any factory engaged in an industry specified in Schedule I of the Act that employs 20 or more employees. To any other establishment employing 20 or more persons. These provisions ensure broad coverage across various industries and establishments. The Act was also extended to establishments in Jammu and Kashmir. From 1st January 2020, the Act applies to establishments employing 10 or more persons that were previously covered under the Jammu and Kashmir EPF and MP Act of 1961. This extension follows the repeal of the Act by the J&K Reorganisation Act of 2019. The Act applies under several key provisions: Section 1, 3, A to any factory engaged in industries specified in Schedule I with 20 or more employees. Section 1, 3, B to any other establishment employing 20 or more persons. Section 2A, departments or branches of an establishment, whether in the same location or different locations, are treated as part of the same establishment. Section 1, 5 Once registered, the Act continues to apply even if the number of employees in the establishment falls below 20. An establishment that is not otherwise covered under the Act can opt for voluntary coverage under Section 1, 4, with the mutual consent of the employer and the majority of its employees. This applies if the establishment has fewer than 20 employees, or it is not listed in the notified industries or classes of establishments. The mutual consent must apply from a prospective date. A notification must be issued in the Official Gazette, and the Central Provident Fund Commissioner, CPFC, can notify this on request from the employer and the majority of employees, or otherwise. There are certain exclusions under the Act, as specified in Section 16. Section 16, 1. A. The Act does not apply to registered cooperative societies that employ less than 50 people and operate without the aid of power. Section 16, 1. B. Establishments under the control of the central or state government are exempt if their employees are entitled to Contributory Provident Fund, CPF, or old age pension under government rules. Section 16, 1. C. Establishments set up under a central or state act are also exempt if their employees receive Provident Fund and pension benefits according to that act. Section 16. To the central government may exempt specific establishments or classes of establishments from the Act for a certain period, considering their financial position or other circumstances. Let us discuss some important terms in reference to the Act. Let's now understand the concept of the appropriate government under the Act. The central government is the appropriate authority for establishments that are under the control of the central government: a railway company, a major port, a mine or an oil field, a controlled industry, or Establishments with departments or branches located in more than one state. The state government is the appropriate authority for any other establishment. Following have been declared as authorized officers under the EPF and MP Act: Central Provident Fund Commissioner, Additional Central Provident Fund Commissioner, Deputy Provident Fund Commissioner, Regional Provident Fund Commissioner, and such other officer as may be authorized by the central government. Let's define basic wages and what it encompasses. Basic wages include all emoluments earned by an employee during their duty, leave, or holidays, as per their employment contract. However, it does not cover the following: cash value of food concessions, any monetary value provided for food. Additional allowances. This includes dearness allowance, house rent allowance, overtime pay, and bonuses. Employer's presents, any gifts or presents given by the employer. Now, let's clarify who qualifies as an employee. An employee is any individual employed for wages in any type of work, manual or otherwise, related to an establishment. Key points include: direct or indirect wages. The person receives wages directly or indirectly from the employer. Contractor-employed individuals. This includes individuals employed by or through a contractor for work connected with the establishment. Apprentices. Includes apprentices not engaged under the Apprentices Act, 1961, or the establishment's standing orders. An excluded employee is defined as follows: an employee who was a member of the fund but has withdrawn the full amount of their accumulation under Clause A or C of subparagraph I of paragraph 69 of the Employees' Provident Fund (EPF) scheme. An employee, other than an international worker or a disabled worker, whose salary exceeds 15,000 rupee per month at the time they become eligible to join the fund. An apprentice. Next, let's define employer in the context of various establishments. Factory. Owner or occupier, the individual or entity owning or occupying the factory. Agent of owner or occupier, a designated representative of the owner or occupier. Legal representative, the individual legally representing the owner or occupier. Manager, the factory manager as defined under Section 7(1)(f) of the Factories Act. Other establishments. Person or authority with ultimate control. This could be the manager, managing director, or managing agent who has ultimate control over the establishment's affairs. As per the governing regulations, a recovery officer can be an officer of the central government, the state government, or a board of trustees. These officers are appointed through an official notification in the Government Gazette, authorized by the central government. The primary role of a recovery officer is to oversee and execute recoveries as per the mandate provided. Now we will discuss some more related sections under the Act. Section 3. Power to apply Act to an establishment which has a common provident fund with another establishment, central government. Section 4. Power to add to Schedule I. Central government, through notification, add to Schedule I any other industry. Section 5. Employees' Provident Fund Scheme. Central government to frame a scheme, its provisions to take effect either prospectively or retrospectively. Fund shall vest in, and be administered by, the central board constituted under Section 5A. Scheme have the matters specified in Schedule 2. The composition of the board includes a diverse group of representatives. The central government appoints a chairman and vice-chairman, ensuring leadership at the highest level. The Central Provident Fund Commissioner serves as an ex officio secretary to the board. Additionally, 5 representatives from the central government and 15 from various state governments are included. Representation from the private sector is also key, with 10 seats each for employers and employees, ensuring balanced perspectives on workforce and management. The financial accountability of the Central Board is ensured in following manner. Board to maintain proper accounts of income and expenditure in a form specified by the central government, in consultation with CAG. The Board's accounts are audited annually by the CAG, and any related expenses are borne by the Board. The CAG has the authority to inspect the Board's records and offices. After audit, the Board must forward the audited accounts, along with the audit report, to the central government, which will then present them to Parliament. Central Board to submit an annual report to the central government, which will also be laid before Parliament. Now, let's examine the composition of the Executive Committee. The Executive Committee is made up of several key members, including a chairman, appointed by the central government from among the members of the Central Board, typically the Secretary of Labour and Employment. The Central Provident Fund Commissioner, CPFC, who serves as the ex officio member secretary. 2 representatives from the central government. 3 representatives from state governments. 3 representatives from employers. And 3 representatives from employees. This diverse representation ensures that all stakeholders, government, employers, and employees, are actively involved in decision-making processes. Next, let's review the key appointments within the Provident Fund framework. First, the central government appoints the Central Provident Fund Commissioner, or CPFC, who serves as the Chief Executive Officer of the Central Board. The CPFC operates under the general control and supervision of the Central Board. In addition, the central government may also appoint a financial advisor and chief accounts officer to assist the CPFC in carrying out their responsibilities. Furthermore, the Central Board has the authority to appoint additional officers as needed. This includes positions like additional Central Provident Fund Commissioners, Deputy Commissioners, Regional Commissioners, Assistant Commissioners, and other necessary staff to ensure the efficient functioning of the Provident Fund system. Now we will discuss appointment and condition of service of officers under CBT. Appointments to CPFC, additional CPFC, FA and CAO, or any Group A or Group B posts under the Central Board, be made in consultation with the UPSC. However, consultation with the UPSC is not required in the following cases. For appointments lasting no more than 1 year. If the appointee is a member of the Indian Administrative Service or is already serving in a Group A or Group B post under the central government, a state government, or the Central Board. The method of recruitment, salary, allowances, discipline, and other service conditions for the CPFC, FA and CAO are specified by the central government, with their salaries and allowances paid from the fund. For other officers and employees, the Central Board specifies the conditions of service based on the rules and orders applicable to corresponding central government posts. If the Central Board needs to deviate from these rules, it must obtain prior approval from the central government. When appointing officers, the Central Board must take into account the educational qualifications, recruitment methods, and the duties and responsibilities of similar roles within the central government. This ensures that appointments align with established standards. If there is any uncertainty regarding these matters, the issue must be referred to the central government. The decision made by the central government in such cases is considered final. The Central Board has the authority to delegate responsibilities to the Executive Committee, the Chairman of the Board, or any of its officers, enhancing flexibility and efficiency in operations. Similarly, a state board may delegate authority to its chairman or any of its officers. This delegation process ensures that decision-making can be more responsive and localized, catering to specific needs effectively. The central government, in consultation with any state government, may constitute a board of trustees for that state, as outlined in Section 5B(1). This is done through an official notification in the Government Gazette. However, until a state board is formally constituted, the chairman of the central board has the authority to establish a regional committee for the state. This committee, set up by official notification, will function under the central board's control, as per Para 4(1). It's important to note that, to date, no state board has been constituted. Let's now look at the Board of Trustees established under Section 5A. The Board of Trustees, once constituted, becomes a corporate body under the name specified in the official notification. This body has perpetual succession, meaning it continues to exist regardless of changes in membership, and it operates under a common seal. In its corporate capacity, the board can sue or be sued under the given name, ensuring accountability and legal standing. Let's begin by discussing the contributions to the Provident Fund. First, the employer's contribution. Employers are required to contribute 10% of the employee's basic wages, dearness allowance, and retaining allowance, if applicable. This contribution is mandatory, regardless of whether the employee is hired directly or through a contractor. Next, the employee's contribution. Employees must contribute an equal amount, 10% of their basic wages, dearness allowance, and retaining allowance. However, if employees wish to contribute more than this 10%, they can do so, but the employer is only required to match up to the statutory 10%. In some cases, specific establishments may have modified contribution rates. The central government may mandate that both employers and employees in certain establishments contribute 12% instead of 10%. Now, let's discuss the calculation of contributions under the scheme. Both the employer and the employee are required to contribute either 10% or 12% of the employee's basic wages, dearness allowance, which includes the cash value of food concessions, and any retaining allowance, if applicable. The specific contribution rate, whether 10% or 12%, depends on the type of establishment and other government specifications. Certain exemptions apply to the Provident Fund contributions wherein contributions are required to be paid at 10%. These exemptions include establishments with fewer than 20 employees, sick industrial companies that have been declared sick by the Board for Industrial and Financial Reconstruction, any establishment that has, by the end of a financial year, accumulated losses equal to or greater than its entire net worth. Additionally, specific industries such as jute, beedi, brick, coir, and guar gum factories also fall under this exemption. Another important scheme under the Act is Employees' Pension Scheme. The central government has the authority to create the Employees' Pension Scheme through a notification in the Official Gazette. The scheme aims to provide the following: superannuation pension, a pension provided upon reaching a specific retirement age. Retiring pension, a pension provided upon early retirement. Permanent total disablement pension, a pension provided in case of permanent total disability. Widow or widower's pension, a pension provided to the surviving spouse of the member. Children pension, a pension provided to the children of the deceased member. Orphan pension, a pension provided to the orphans of the deceased member. Pension fund will be vested in and administered by the Central Board. Pension scheme may include provisions for any matters listed in Schedule 3 of the Act. Pension scheme, once framed, must be presented before both Houses of Parliament for a total of 30 days, which may span one or more sessions. Now, let's talk about the establishment of the pension fund. The pension fund was created to manage both contributions and payouts related to employee pensions. Contributions to the pension fund come from several sources. A portion of the employer's contribution, up to 8.33% of the employee's basic wages, dearness allowance, and retaining allowance, as specified under Section 6. Contributions from employers of exempted establishments, as outlined in Section 17(6). The net assets of the employee's family pension fund at the time of the pension fund's establishment. And any additional sums specified by the central government, as approved by Parliament. This pension fund replaces the previous family pension scheme. As part of the transition, all assets and liabilities of the family pension scheme are transferred to the new pension fund. Importantly, beneficiaries of the old scheme will continue to receive benefits from the pension fund, ensuring that their entitlements are at least equal to what they were previously receiving. Now, let's take a look at the special provisions for employees with disabilities. The central government will contribute the employer's share of the Provident Fund for employees with disabilities. This contribution applies for up to a maximum period of 3 years from the date the employee joins the fund. This benefit is available whether the employee is hired directly by the principal employer or through a contractor, provided the employee earns a wage of up to 25,000 rupee per month. This provision is aimed at encouraging the employment of persons with disabilities by alleviating the financial burden on employers. Let's take a look at how the wage ceiling for Provident Fund contributions has evolved over the years. From 1 November 1952 to 31 May 1957, the wage ceiling was 300 rupees. From 1 June 1957 to 30 December 1962, it increased to 500 rupees. Between 31 December 1962 and 10 December 1976, it rose to 1,000 rupees. From 11 December 1976 to 31 August 1985, it reached 1,600 rupees. From 1 September 1985 to 31 October 1990, the ceiling was 2,500 rupees. Between 1 November 1990 and 30 September 1994, it increased further to 3,500 rupees. From 1 October 1994 to 31 May 2001, it was 5,000 rupees. From 1 June 2001 to 31 August 2014, the wage ceiling was 6,500 rupees. Finally, from 1 September 2014 onwards, the current wage ceiling is set at 15,000 rupees. This progressive increase reflects the growing economic conditions and adjustments to keep up with inflation over the decades. Now we will be discussing the Employees Deposit-Linked Insurance Scheme, a significant initiative under the Employees Provident Funds and Miscellaneous Provisions Act. First, the scheme is introduced by the central government through an official notification. Its core purpose: to provide life insurance benefits to employees who work in establishments covered under the Act. A deposit-linked insurance fund is set up and is managed by the Central Board. As part of this, employers are mandated to contribute to this fund on behalf of their employees. The contribution from the employer's side cannot exceed 1% of the employee's basic wages, dearness allowance, and retaining allowance. The exact contribution percentage, however, will be specified by the central government in due course. Employers may also be required to pay an additional amount, up to 1/4 of the required contribution, to cover administrative expenses for managing the scheme. Again, this amount is determined by the central government and does not include the costs of providing benefits under the scheme. Lastly, the scheme may also cover provisions related to matters listed under Schedule 4 of the Act. Next, let's dive into Section 7, which plays a key role in resolving disputes under the Employees Provident Funds Act. The Central Provident Fund Commissioner, along with designated officers such as the Additional, Deputy, Regional, and Assistant Provident Fund Commissioners, is empowered to handle two primary tasks. First, they have the authority to decide disputes regarding the applicability of the Act to any establishment. This ensures that the Act is enforced where necessary. Second, they determine the exact amount of money an employer owes under the Act, be it under the Provident Fund, the pension scheme, or the insurance scheme. To perform these duties, these officers can conduct inquiries as needed. It's important to note that such inquiries are considered judicial proceedings, aligning with Sections 193, 228, and 196 of the Indian Penal Code. This gives the process legal weight and ensures accountability. Most importantly, employers have the right to be heard. No decision or order can be passed against an employer unless they've been given a fair opportunity to present their case. This ensures transparency and fairness in the proceedings. Let's now focus on what happens if someone fails to comply with an inquiry under Section 3A and how ex parte orders are handled. First, the consequences of non-attendance. If any person, whether an employer, employee, or other relevant party, fails to attend the inquiry, produce required documents, or submit necessary reports without a valid reason, the 7A officer can still proceed. The officer will determine the dues based on the evidence and records available at that time. Next, let's discuss ex parte orders. If an order is issued against an employer without their presence, they can apply to have the order set aside within 3 months. However, they must prove either that they were not properly notified or had a sufficient reason for not attending the inquiry. But there are limitations. If the employer was properly notified and had ample time to attend but still didn't show up, the ex parte order may not be set aside simply due to minor errors in serving the notice. Finally, if an appeal against an ex parte order was dismissed for reasons other than withdrawal by the appellant, no further applications to set aside the ex parte order can be made under this subsection. Now, let's discuss the specific powers granted to the 7A authority. Under the Act, the 7A authority has several important enforcement tools at their disposal. First, they can enforce the attendance of any person and examine them under oath. This ensures that key witnesses or individuals involved must participate in the inquiry process. Second, they have the authority to require the discovery and production of relevant documents. This power is essential for gathering necessary evidence to make informed decisions. Third, they can receive evidence in the form of an affidavit. This allows for written testimony to be provided and considered during the inquiry. Lastly, they can issue commissions to examine witnesses. This means they can delegate someone to gather testimony from individuals, even if they are unable to attend the proceedings in person. Together, these powers ensure that the 7A authority has the legal means to conduct thorough and fair investigations. Now, let's go over the salient points under Section 7A that ensure a fair and transparent process during the inquiry. First, summons must be served. This ensures that all relevant parties, including employers and employees, are properly notified about the inquiry proceedings. Second, each party is given a fair opportunity to defend themselves. This means they can respond to the claims and present their side of the story. Third, there is an opportunity to present evidence. Both the employer and the employee can submit any documents, testimonies, or other relevant materials to support their case. Finally, the officer must issue a speaking order. This means that the decision or order passed must clearly outline the reasoning and basis for the decision, ensuring transparency and accountability. Together, these key points uphold fairness throughout the 7A inquiry process. Next, let's explore Section 7B, which deals with the review of orders passed under Section 7A. If someone is aggrieved by an order made under Section 7A and has not yet appealed, they may apply for a review, but only under certain conditions. First, a review can be sought if new and important evidence has surfaced, evidence that was not available at the time of the original decision, despite due diligence. Second, a review is allowed if there's an apparent mistake or error on the face of the record, such as factual inaccuracies or legal oversights. Third, a review can be requested for any other sufficient reason that justifies re-examining the case. In addition, the officer who passed the order can review it on their own motion if they believe it's necessary. Regarding the time limit, applications for review must be submitted within the period specified in the scheme. For the review process, the officer has the authority to reject the application if there are no sufficient grounds. However, if the review is granted, prior notice must be given to all involved parties, ensuring that everyone has a chance to be heard before a new decision is made. Let's now look at the conditions for granting a review and the related appeals process under Section 7b. First, when a review is requested, the officer must ensure that the new evidence could not have been produced earlier. This means the applicant needs to demonstrate that, despite their efforts, the evidence was unavailable at the time of the original order. If the review is granted based on this new evidence, the applicant must provide solid proof that this evidence was not available earlier. Now, moving to appeals. If an application for review is rejected, no appeal can be made against this rejection. However, if a new order is passed during the review, it can be appealed in the same manner as the original order under Section 7a. Now, let's discuss Section 7c, which covers the determination of escaped amounts. Under this section, an officer may reopen a case and redetermine the amount owed by an employer within 5 years of the original order passed under Section 7a or 7b. This can happen under two main conditions. First, if there was an omission or failure on the employer's part to disclose all the necessary documents or material facts during the original inquiry. In other words, if something crucial was withheld, the case can be revisited. Second, if new information comes to light, suggesting that an amount due was not determined during the original inquiry, even if there was no fault or omission on the employer's part. This ensures that any overlooked dues can still be addressed. Before any redetermination order is passed, the employer must be given a reasonable opportunity to represent their case. This allows the employer to present their side and ensures a fair process. Let's move on to Section 7i, which covers the process of appeals to the tribunal. Who can appeal? Any person who is aggrieved by a notification or order issued by the central government or any authority under various sections of the Act, including Sections 1, 3, 3, 7a, 1, 7b, 7c and 14b, can file an appeal with a tribunal. However, orders rejecting a review application under Section 7b, 5, cannot be appealed. Now, let's discuss the procedure of tribunals. Tribunals have the power to regulate their own procedure, including deciding where they will hold their sittings. Tribunal powers include all the powers vested in officers under Section 7a. Additionally, any proceeding before the tribunal is considered a judicial proceeding. This means it carries the same legal weight as those outlined in Sections 193, 228, and 196 of the Indian Penal Code. Furthermore, for certain legal purposes, the tribunal is treated as a civil court, specifically for matters under Section 195 and Chapter XXVI of the Code of Criminal Procedure, 1973. Let's take a look at the orders of the tribunal and how decisions are made. After hearing both parties involved, the tribunal can confirm, modify, or completely annul the original order. In some cases, they may even send the case back to the original authority for fresh adjudication, giving them specific directions. Additionally, if a clear mistake is found in its previous decision, the tribunal has the power to amend its orders within 5 years. However, if this amendment increases the employer's liability, the tribunal must notify the employer and provide an opportunity for them to present their case. It's important to note that once the tribunal passes an order, it cannot be challenged in any court of law. Finally, if an employer wishes to appeal the tribunal's decision, they are required to deposit 75% of the amount determined under Section 7A. However, the tribunal may waive or reduce this deposit, provided they offer written reasons for doing so. Now, let's discuss Section 7Q of the Act. Under this section, the employer is required to pay simple interest at a rate of 12% per annum, or a higher rate as specified in the scheme, on any amount that is due from them under the Act. This interest accrues from the date the amount becomes due until the date of actual payment. It's important to note that this provision was introduced in 1997, adding further accountability for timely payments. Recovery of monies by employers and contractors. Employers can recover both the employer's and the employee's contributions to any scheme and the employer's contribution to the insurance scheme related to admin charges. Method of recovery. Employers can recover these amounts from contractors in two ways: deduction from payments to contractors. The employer may deduct the contributions and charges from any amount payable to the contractor under any contract. As a debt, the employer may treat these amounts as a debt payable by the contractor. Recovery of employees' contribution by contractors. Contractors are permitted to recover the employee's contribution to the Provident Fund from the employee's wages. Method of recovery. The contractor can deduct the employee's contribution from wages payable to the employee. Let's now turn to the restrictions placed on contractors regarding the recovery of employers' contributions. There is a clear prohibition. Contractors are not allowed to recover the employer's contribution or the administrative charges for managing the fund from the employee's wages. This rule applies regardless of any contract between the contractor and the employee, ensuring that the responsibility for these payments remains solely with the employer. Next, we'll look at the process of issuing a certificate for recovery. An authorized officer has the power to issue a certificate to the recovery officer. This certificate contains details of the arrears that need to be recovered from the establishment or employer. The recovery officer can take several actions to recover the dues. Attachment and sale of property. The officer can attach and sell both movable and immovable property belonging to the establishment or employer, with the priority being the establishment's property. Arrest and detention of the employer. In cases of severe non-compliance, the employer can be arrested and detained. Appointing a receiver. A receiver may be appointed to manage the movable or immovable properties of the establishment or employer for the purpose of recovering the arrears. These steps ensure that the recovery process is thorough and effective. Let's expand on the authority of the authorized officer in issuing a certificate for recovery. The authorized officer can issue a certificate to the recovery officer even if other methods to recover the arrears have already been initiated. This means that actions for recovery can be simultaneous or overlapping, providing a more robust and efficient way to recover the outstanding amounts. This flexibility ensures that all avenues are explored to collect the dues from the employer or establishment. Now, let's discuss the jurisdiction of the recovery officer when enforcing a certificate for recovery. The certificate is sent to the recovery officer who has jurisdiction where the employer carries on their business or profession, has their principal place of establishment, resides, or where any movable or immovable property of the establishment or employer is located. In cases where the employer's property spans multiple jurisdictions, the recovery officer can take two actions. Partial recovery. If the officer cannot recover the full amount from the property in their jurisdiction, they can forward the certificate, or a certified copy, to a recovery officer in another jurisdiction. Expediting recovery. If the officer believes that involving another jurisdiction would expedite or better secure the recovery, they can forward the original or certified copy of the certificate to another recovery officer. This approach ensures that recovery efforts can cross multiple regions, maximizing the chances of collecting the arrears. Let's take a closer look at the process of certificate issuance and how it impacts employer objections. Once the authorized officer issues a certificate to the recovery officer, the employer is not allowed to dispute the correctness of the amount before the recovery officer. In fact, no objections regarding the issuance of the certificate will be entertained at this stage. However, despite the certificate being issued, the authorized officer has the authority to either withdraw the certificate or correct any clerical or arithmetical errors within it. Any such changes must be promptly communicated to the recovery officer to ensure the recovery process is accurate and up to date. Next, let's explore how payment extensions and modifications affect the recovery process. Even after a certificate has been issued for recovery, the authorized officer has the discretion to grant additional time for payment. If such an extension is granted, the recovery officer is required to pause all recovery proceedings until the granted time has expired. Should any amount be paid, or if more time is allowed after the certificate is issued, it's the responsibility of the authorized officer to inform the recovery officer about these updates to avoid any unnecessary recovery actions. If the original order that led to the demand is modified, for instance through an appeal that reduces the demand, the authorized officer must stay the recovery of the reduced amount. This stay will remain in place until the appeal or related proceeding is fully resolved. Finally, once the appeal or proceeding is concluded, and the demand is officially reduced, the authorized officer is required to either amend or withdraw the recovery certificate accordingly. Now, let's explore the alternative modes of recovery available, even after a recovery certificate has been issued to the recovery officer under Section 8B. The Central Provident Fund Commissioner or any authorized officer can still recover the outstanding amount through other methods provided in this section, including deduction from payments due to employers. If another party owes money to an employer who is in arrears, the Commissioner or authorized officer can instruct that party to deduct the arrears from the amount owed to the employer and pay it directly to the Commissioner. However, this provision doesn't apply to amounts that are exempt from attachment under Section 60 of the Code of Civil Procedure, 1908. Application to the court. The Commissioner can apply to the court holding funds belonging to the employer, requesting the court to release enough money to cover the arrears. Distraint and sale of movable property. If authorized by the central government, the Commissioner or an officer not below the rank of Assistant Provident Fund Commissioner can recover the arrears by seizing and selling the employer's movable property, following the procedures laid out in the third schedule to the Income Tax Act, 1961. These methods provide flexibility and ensure multiple avenues are available for recovering dues from employers in arrears. Under the provisions for notice to third parties, the Commissioner or an authorized officer has the authority to issue a notice to any person who owes or may owe money to the employer. This notice instructs them to pay the amount due directly to the Commissioner, rather than to the employer, even if the money is held jointly. A copy of this notice is also sent to the employer and any joint holders. The recipient, whether it's a bank, post office, or insurer, must comply without needing to provide any additional documents for payment. Importantly, any claims made on the property after the notice date are considered void against the notice demand. However, if the recipient objects to the notice on valid grounds, they aren't required to comply unless their objection is deemed false. In such a case, they may become personally liable. The Commissioner has the power to amend, revoke, or extend the notice as necessary. Payments made under the notice effectively discharge the payer from any liability to the employer for the amount paid. But, failure to comply with the notice may result in the third party being treated as the employer in default, which could lead to further recovery proceedings. This section makes it clear that the recovery processes under this Act will follow the provisions laid out in the 2nd and 3rd Schedules of the Income Tax Act, 1961, as well as the Income Tax Certificate Proceedings Rules, 1962. However, these provisions and rules are to be interpreted with a specific focus. They should be understood as referring to the recovery of arrears under Section 8 of this Act, not the usual income tax arrears under the Income Tax Act. Under Section 9, for the purposes of the Income Tax Act of 1961, the fund will be recognized as a Provident Fund. Specifically, it will be deemed as a recognized Provident Fund, as defined under Chapter 9A of the Income Tax Act. Section 10 provides protection against the assignment or attachment of Provident Fund amounts. Essentially, the amount standing to the credit of any member in the Provident Fund cannot be assigned, used as collateral, or attached to satisfy any debts or liabilities incurred by the member. This protection extends even in cases of insolvency, meaning insolvency officials like an assignee under the Presidency Towns Insolvency Act of 1909, or a receiver under the Provincial Insolvency Act of 1920, cannot claim these funds. Moreover, in the event of a member's death, any amount payable to their nominee from the Provident Fund is fully protected. It cannot be claimed by creditors, nor can it be attached under any court order. This protection also applies to any amounts payable under family pension schemes, or insurance schemes. In the case of an employer's insolvency or when a company is winding up, contributions to provident funds and insurance funds, along with any related damages and charges, are given priority over other debts. These amounts are treated as preferential debts, meaning they must be paid first from the employer's assets. This ensures the protection and security of employees' benefits, regardless of the establishment being regular or exempted. This protection overrides any conflicting legal provisions. The priority applies to amounts due from the employer before the insolvency adjudication or winding up order, including contributions payable to the Provident Fund or Insurance Fund, damages recoverable under Section 14B, accumulations required to be transferred under Section 15(2), and other charges payable under any provision of this Act, the scheme, or the insurance scheme. Section 12 provides critical protections for employees. First, it prohibits employers from reducing the wages of any employee, either directly or indirectly, due to their obligation to pay contributions to the Provident Fund, Insurance Fund, or any related charges under the Act or its associated schemes. Additionally, employers cannot reduce the total benefits that an employee is entitled to, including old age pensions, gratuities, provident funds, or life insurance, whether these benefits are explicitly stated in the terms of employment or implied. This ensures that employees' earnings and benefits remain safeguarded, even when the employer is liable for contributions. The appropriate government holds the authority to appoint inspectors, as outlined in the Act. This is done through a notification in the Official Gazette, and these inspectors are appointed specifically to oversee compliance with the Provident Fund scheme, pension scheme, and insurance scheme. The government also defines the jurisdiction of these inspectors, specifying the areas or establishments they are responsible for monitoring. When it comes to search and seizure, the procedures laid out in the Code of Criminal Procedure, 1898, apply. This means that any search or seizure conducted by inspectors must follow the same legal protocols as those required under a warrant issued under Section 98 of the Code. This ensures that all actions are legally regulated and properly authorized. The role of inspectors under the Act serves several key purposes. They are tasked with verifying the accuracy of any information submitted in connection with the Act or its related schemes. Their responsibilities also include ensuring that establishments comply with the Act and determining whether the Act applies to specific establishments. For exempted establishments, inspectors check if the conditions of their exemptions under Section 17 are being met. In terms of specific powers, information gathering, inspectors can require employers or contractors, from whom amounts are recoverable under Section 8A to provide necessary information. Entry and search. Inspectors have the right to enter and search any establishment or premises at a reasonable time, examining accounts, books, and other employment-related documents. Examination of persons. They can question employers, contractors, agents, or employees to gather relevant information. Document seizure. If necessary, inspectors can take copies or extracts from documents and, if an offense is suspected, they can seize these documents with appropriate assistance. Additional powers. They may also exercise any other powers granted under the scheme or the insurance scheme, ensuring compliance and legal enforcement. Now we will be discussing the penalties for violation of provisions of the Act and SCHMES framed thereunder. Under the provisions related to false statements or representations, any person who knowingly makes or assists in making a false statement or representation to avoid payment under the Act, the scheme, the pension scheme, or the insurance scheme, is subject to penalties. These penalties include imprisonment for up to 1 year, a fine of up to 5,000 rupees, or both. However, in certain cases, the court may impose lesser imprisonment, provided they record adequate and special reasons in the judgment. Legal consequences of non-payment and non-compliance with employee contribution regulations. Employers are required to deduct and remit employee contributions from wages. Failure to do so, including not covering administrative or inspection charges as stipulated in Sections 6, 17, 3A, and paragraph 38 of the scheme, leads to severe penalties. For defaults involving non-payment of deducted employee contributions, employers face imprisonment for up to 3 years. The minimum term is 1 year, alongside a fine of Rs10,000. In other instances of non-payment, the minimum imprisonment is 6 months, accompanied by a fine of 5,000 rupees. For violations of Section 6C, employers may be imprisoned for up to 1 year, with a minimum term of 6 months. Additionally, they could face a fine of up to 5,000 rupees. To summarize on nature of offence and relevant provisions related, non-payment of employees and employers' share of contribution is violation of Section 6 of EPF and MP Act. Non-payment of administrative charges under EPF scheme is violation of Para 38 of EPF scheme. Non-payment of inspection charges is violation of Section 17, 3A, under EPF scheme. Non-payment of EDLI contribution, 0.5%, and admin charges is violation of Section 6C of the Act. In case of general non-compliance with the Act, scheme, pension scheme, or insurance scheme, the consequences can include imprisonment for up to 1 year, a fine of up to 4,000 rupees, or both. However, if there is non-compliance without a specific penalty, meaning the Act doesn't provide a specific penalty for a violation, or if there's a breach of the conditions under which an exemption was granted under Section 17, the violator may face imprisonment for up to 6 months, with a minimum of 1 month. Additionally, a fine of up to 5,000 rupees may be imposed. Various defaults can lead to serious consequences under the regulations. These include default in payment of contribution under Section 6, default in payment of inspection charges under Section 17, 3A, default in payment of administrative charges under Paragraph 3. The maximum punishment for these offences can be up to 3 years of imprisonment. Specifically, for the default in payment of contributions under Section 6, the imprisonment term is not less than 1 year, along with a fine of 10,000 rupees. For the other defaults, imprisonment is not less than 6 months, with an additional fine of 5,000 rupees. Liability of individuals in charge. If a company commits an offence, every person responsible for the conduct of the company's business at the time of the offence is deemed guilty and liable for punishment. However, if an individual can prove that the offence was committed without their knowledge or that they exercised due diligence, they may avoid punishment. Liability of company officials. If the offence was committed with the consent or connivance of, or due to neglect by, a company's director, manager, secretary, or other officers, they are deemed guilty and liable for punishment. Enhanced punishment for repeat offenders. For repeat offenders, the consequences are more severe. Anyone previously convicted under the Act who commits the same offence again may face imprisonment for up to 5 years, with a minimum of 2 years, and a fine of 25,000 rupees. Cognizable offences. Offences related to the default in payment of contributions by employers are classified as cognizable offences. This means that authorities have the power to arrest the offenders without a warrant. Cognizance and trial. Courts can only take cognizance of offences under this Act if there is a written report sanctioned by the Central Provident Fund Commissioner or an authorised officer. Furthermore, these offences must be tried by a presidency magistrate or a magistrate of the first class. Exclusion from the Act includes the following: cooperative societies. Establishments registered under the Cooperative Societies Act, 1912, or any other law related to cooperative societies are excluded if they meet 2 criteria. They employ less than 50 persons. They operate without the aid of power. Government-controlled establishments. Any establishment that belongs to or is under the control of the central or state government is excluded if the employees are entitled to the benefits of a contributory provident fund, or an old age pension, as per any scheme or rule framed by the central or state government. Establishments set up under specific acts. Any establishment set up under any central, provincial, or state act is excluded if the employees are entitled to the benefits of a contributory provident fund, or an old age pension, as per any scheme or rule framed under that specific act. The central government holds the authority to exempt certain classes of establishments from the application of this Act if it deems it necessary or expedient. This exemption can be based on factors such as the financial position of a particular class of establishments, or other relevant circumstances. Notification requirement. To formalize this exemption, it must be specified in a notification published in the Official Gazette. This notification can apply the exemption either prospectively or retrospectively. Additionally, the exemption is subject to the conditions specified in the notification and is only valid for the period mentioned within it. The appropriate government can, by notification in the Official Gazette, exempt any establishment from the provisions of any scheme under specific conditions. A. Exemption based on Provident Fund rules. An establishment may be exempted if its Provident Fund rules regarding contribution rates are at least as favorable as those specified in Section 6. Additionally, the employees must enjoy other Provident Fund benefits that are not less favorable than those provided under this Act or any similar establishment. B. Exemption based on other benefits. An establishment may also be exempted if its employees receive benefits such as a provident fund, pension, or gratuity. These benefits, whether provided separately or jointly, must be at least as favorable as those under this Act or any similar establishment. Consultation with the Central Board. No exemption under subsection 1 can be granted without consulting the Central Board. the Central Board is required to forward its views within a specified time limit. Even if an establishment is exempted, Sections 6, 7, 8, and 14b will still apply to the employer. Any violation of these sections will lead to punishment, just as if the establishment had not been exempted. The employer must also establish a board of trustees to manage the Provident Fund. The terms and conditions of service for members of this board will be outlined in the scheme. The Board of Trustees is responsible for maintaining accounts, submitting returns, investing Provident Fund money as directed by the central government, transferring Provident Fund accounts, and performing other duties as specified in the scheme. The appropriate government may exempt any establishment or class of establishments from the pension scheme if employees are members of another pension scheme that offers benefits at par with or more favorable than those under this Act. Similarly, exemptions for individuals or classes of persons employed in an establishment can be granted if they are entitled to benefits that are not less favorable than those under this Act. For the insurance scheme, the Central Provident Fund Commissioner may exempt establishments if employees enjoy more favorable life insurance benefits without making separate contributions. Individuals or classes of persons can also be exempted if they receive more favorable insurance benefits. Exemption from the Provident Fund scheme is granted by the appropriate government. The main condition is that the rates of contribution must not be less than those specified under Section 6 of the Act. Additionally, employees must be receiving other benefits that are not less favorable than those provided under the PF scheme. Exemption from all schemes is granted by the appropriate government. The main condition for such an exemption is that employees must be receiving Provident Fund, pension, and gratuity benefits. Whether provided separately or jointly, these benefits must not be less favorable than those under the existing schemes. Exemption from the Employees' Pension Scheme, EPS, of 1995 is granted by the appropriate government. The main condition for exemption is that the pensionary benefits provided must be at par with or more favorable than those under EPS 1995. Additionally, the exemption is subject to adherence to specific conditions regarding the pattern of investment. Exemption from the Employees' Deposit-Linked Insurance, EDLI, scheme of 1976 is granted by the Central Provident Fund Commissioner. The main condition for exemption is that no separate contribution or payment of premium is required. The life insurance benefits may or may not be linked with the employee's deposit, but these benefits must be more favorable than those provided under the EDLI scheme. Both the original employer and the transferee, or the person to whom the establishment is transferred, are jointly and severally liable for any contributions and sums due under the provisions of the Act, the scheme, the pension scheme, or the insurance scheme. This liability covers the period up to the date of the transfer of the establishment. However, the liability of the transferee is limited to the value of the assets obtained through the transfer. According to Section 18 of the Act, no suit, prosecution, or other legal proceedings can be initiated against an inspector for actions taken in good faith under the Act and the schemes framed therein. Additionally, under Section 18A, every inspector is deemed a public servant as per Section 21 of the Indian Penal Code. Under the Employees' Provident Fund Act, the central government holds the authority to issue directions to the Central Board for the efficient administration of the Act. These directions are binding, and the Central Board must comply with them. Thank you for watching. For more informative videos, please access our bouquet of programs.